director of the public complaints unit of the Judicial Service. We investigated. The person who allegedly took the money from that person entered the courtroom and bowed to the judge. The judge did not know him. Just to give it a semblance that he had given the money to the judge and was coming to bow, to show that the person who is accompanying him is the person who gave out the money to him.
Charlie, welcome to the Political Rant with me, the voice writer on Ghana and TVGH. Please like, comment, subscribe, share, turn on the notifications so that anytime videos of this nature are uploaded, you'll be notified.
And I do agree with you that if the president is not there, the vice president is not there, the speaker. If all of them are not there, the vice president and the president are not there for a given period, the assumption is that, let's say, if they are not there and will not come back, if they will not come back, then there must be an election in 3 months, and a new president will have to take over. So clearly the Constitution is firm on the people who can occupy the position of president or acting president, and for what duration they can act as president. So what could have necessitated an arbiter to the effect that Chief Justice can act as a president? What, on the basis of which provisions did that come up?
Thank you. It was by Professor Kruje in the case of Asarabes Attorney General, which I personally, even though it is an arbiter, I disagree. Because if you are interpreting, you must interpret within the context, and you must be fair. You must be fair to the text. Faithfulness, that is cardinal principle in interpretation, faithfulness to the text. Where it has not been stated anywhere, but I do not blame him because he was discussing the position of 1960. Sense of the government. So he used that one because '57 is different from 1992 Constitution. So at no point in time can you compare the two. So if you look at, he was influenced by that position, but within the context of the Constitution, it cannot be so. Thank you.
Is it desirable in the context of separation of powers to ever place the head of the judiciary as the head of the executive?
No, please, because we had one in 1957 which brought about Stowell will travel to England, and the Chief Justice was signed to make him unpopular. So it is not advisable to use the Chief Justice as one of the to exercise one of the executive powers. It is not advisable. Thank you.
Because within the context of separation of powers, if the person who is the arbiter becomes the actor, how do we resolve misconduct by that person or wrongful conduct by that person that gets contested in your court?
Thank you. Thank you, Honorable. It could be a bad practice, because why do you involve a judge or Chief Justice whose role is resolution of disputes, which is different from the role of the executive? If it extends to Parliament, there's nothing wrong because they are politicians. They were voted for. They put up their campaign, and at the end of the day, they were voted for. So they can act. But where the Chief Justice, you are supposed to be independent, impartial, and you are to go and perform executive function, it will violate every principle of rule of law. Thank you.
Now, looking at, I think you, from your previous answers, you seem to me as a judge who has some belief in the purposive approach to constitutional interpretation.
I have several publications on it. Thank you.
So you endorse purposive interpretation?
But leader, so I take it that you are now having your turn.
Having my turn.
Very well.
You endorse the purposive approach to constitutional interpretation?
That is so.
Now, Article 60 talks about two scenarios: absence from the country and inability to perform your functions.
So that when the case is done,
From a
when the judge
purposive
passes judgment,
approach to
this is
interpretation,
my judgment, then you can come
in
out
this
and say,
era where absence from the country is not the same as inability to perform your
this
functions,
Attorney General,
in view of developments in telecommunications and etc.,
academic,
where you can even sit abroad and then chair a cabinet meeting, where you can sit abroad and receive briefings. In fact, on your aircraft, you can actually chair a cabinet meeting taking place in the Flagstaff House. So on a purposive interpretation to our Constitution, given that the Constitution is anticipating absence from Ghana based on an assumption in 1992 that when you are physically absent, you will not be able to exercise your function as president, or where you are actually here but you are unable to perform, maybe due to ill health or some other consideration. Given that that is not really something that practically exists now, can we say that at any moment a president is absent from Ghana and as a result unable to perform his functions, by which reason, when both president and vice president are not there, there is a fundamental breach of the Constitution?
Thank you, Chair. When we talk about unable to perform his function, and it is outside or he's outside the jurisdiction. And if you look at the decisions rendered by the Supreme Court, the one against Honorable Do Ajaho, the Supreme Court said that no, the person must be physically present in Ghana. That was the intention at the time the law was made, because we were scared of soldiers, that the least the soldiers will come. And therefore, as a commander-in-chief, if you are not there, somebody should take over from you. And as I said, when we take into account purposive interpretation, what we do is that we look at the law. We look at having looked at the law, then the next thing that we do is we look at the context within which it was made, context. So having taken it out of the context, then we move to the second stage. We look at the purpose, the subject matter, the scope, and to some extent the background. What informed that? The background, does it still prevail? So I believe if there is a new application, nothing will prevent the Supreme Court may take into account technology, development, and move to different level. Nothing may prevent it, because if it is to be construed purposively, then whether the president is in Ghana or not, provided he's not sick, he's not seriously sick and can perform his function, I don't think this should be a critical issue. Thank you, Honorable.
And can you reconcile a situation where the president is attending the United Nations General Assembly on behalf of Ghana in his capacity as president? He's there in his capacity as president, sometimes even on a state visit in his capacity as president. And then in his absence, the vice president is sworn in as the acting president. At that time, do we have two presidents for Ghana? The vice president is acting as the president. Yes. So the point I'm making is, do we have one president acting outside Ghana and another president acting in Ghana?
Thank you, Honorable Chair. Honorable Chair, that is why from the beginning I said that there is an issue with that decision, but it is binding on everybody until it is varied or set aside. But as you know, Supreme Court decision can change at any time, provided it is policy, such as this one. It can change at any time. That is why we say that it is a living organism capable of growth. And in the case of Zenita Lawrence, Justice Tuguba openly stated that because of modern purposive approach, meanings can change at any time. And therefore, if you go for even interpretation and you think that the meaning has changed as a result of time, circumstances, and the purpose, you can still go back to the same court. So I am of the considered opinion that now that we have modernization, technology, and those things, that position, in future, if the opportunity avails itself, it should be changed. Thank you, Chair.
That will not amount to rewriting the Constitution, will it? Because the language of Article 60 is quite clear. The circumstances have changed. That renders its application funny, if I may put it that way. But the language hasn't changed, and the language is not open to different interpretations and fidelity to the language of the Constitution. Will you keep changing the language of the Constitution because circumstances have changed that make its application quite, uncomfortable?
Thank you, Chair. Yes, that is why now in most countries those use constitution. They are talking about either living constitutionalism or purposive interpretation. Whichever you look at it from, if it is a living organism, if at the beginning it was at the ground level and circumstances are changing, the constitution will grow. And that one, it will not materially affect the substance. It is the meaning that you are going to attach to it. And either you use purposive approach to interpretation or the living organism, which the Constitution is supposed to grow, which Ghana has embraced. Into 4 and Attorney General, it has been celebrated that the Constitution in Ghana will grow. Otherwise, if you talk about pedantism, then we are going to talk about literalism. The Constitution will never grow, and it will cease to be a constitution. It will be treated like any other document, such as Ordinary Act of Parliament or CI or LI. But the Constitution is different. That is why we say it is sui generis. It is unique, and because it is unique, its interpretation may change depending on the circumstances, but it will not affect the substance of the law. And what I would also like to say is that when we are talking about living constitutionalism or purposive interpretation, what we seek to do is that the Constitution must be able to address normal and or abnormal circumstances through proper interpretation. Thank you.
I'm being gagged by my chairman. He says that I've asked enough questions.
No, it's far from that. I will then proceed to give the floor to Honorable Ewa.
CV and your own account, before joining the bench, you practiced as a lawyer from Holy Trinity Chambers. Can you please, by way of clarification or information, let us know whether it's a partnership or a limited liability company or a company unlimited by shares?
Thank you, Chair. Chair, in Ghana, you can register a company, a law firm, as either sole proprietorship, unlimited liability, or partnership.
My Lord, I want to know whether Holy Trinity, what is its legal
sole
status?
proprietorship.
What you want, but it is the answer that the nominee wants to provide.
It was registered as sole proprietorship, and it was Dennis Eje Legal Consult of Holy allow companies to be registered in Ghana as a limited liability. Is that once you own a firm, your liability is unlimited, because if you dupe somebody, you use fraudulent means to take money from your client, and you say that it is limited to my shares. No, it is limited to your own properties. That is why no country allows a company to be, a law firm to be registered as a limited liability. It can be unlimited, partnership, or sole proprietorship. So Holy Trinity was sole proprietorship.
Now to my substantive question. I wanted information.
You don't have a preliminary question and a substantive question, so you can either ask a follow-up.
Mr. Chair, very respectfully, the basis for my question was the reason why I sought clarification.
Honorable member, you are entitled to one question. You have asked the one question. So if you don't have a follow-up, let me give the floor to another person.
What do you make of a lawyer who maintains an interest in a firm after he has joined the bench? What do you make of it? Is it appropriate?
Honorable member, this cannot be a follow-up question. The question is accordingly overruled. I will then proceed to give the floor to Honorable Akurugu.
Thank you, Mr. Chair. Congratulations. elevation. You're almost there if you pass the test. Now, let's look at AI, artificial intelligence. With the emergence of artificial intelligence and the spread of fake news, fake accounts, would you support the criminalization of misinformation, disinformation, and the posting of or setting up of fake accounts? Would you support that?
Yes, please, because if you do it ordinarily, it is an offense. And therefore, if you transpose it to social media, it should be an offense. Thank you.
Now, don't you see such a legislation as a threat to free speech?
No, please, Ghana, we have the Communication Act. The Communication Act has criminalized some acts. Because, for example, if you want to expose the nudeness of somebody, you are saying something that is prejudicial to the security of the state, and you do it on social media. If you do it in the country physically, it is an offense. And therefore, if you do it on social media and it is an offense, it is not an extension of anything. Assuming it is not an offense if it is done within the jurisdiction, and you do it on social media, and we are criminalizing it, that one, it will be wrong. But if you do it in Ghana, physically, it is an offense. So wherever you do it, it should be an offense. Ethics, a component of whatever training that we give, either to the judiciary, the judicial officers or staff. The reason is that when we are talking about corruption, we are talking about something which is bad, then we must make it a conscious effort to fight it. If you do not fight it, it will become endemic. And therefore, the most important thing is that we need to first and foremost conscientize ourselves about the effect of corruption. Then the second one, what do we do to curb it? We need education. We need training. Then one thing that people of Ghana that you don't do is that if a public officer, either me or any other person, demands money from you, you must report the person. You will condone. You will give it. Then when it comes to assessment, you say that you will not mention the name. Then say that the whole judiciary is corrupt. That is the problem, and it is about perception. And I can talk about personal experience as a director of the Judicial Training School. On one occasion, I was training. Then somebody came to me to complain about somebody who was taking money from him. We made the inquiries. I was then the director of the Public Complaints Unit of the Judicial Service. We investigated. The person who allegedly took the money from that person entered the courtroom and bowed to the judge. The judge did not know him. Just to give it a semblance that he had given the money to the judge and was coming to bow to show that the person who is accompanying him is the person who gave out the money to him. But it was false. So these are some of the things that we do and we must stop. In most cases, if you listen to some of the TV discussions, social media, you know, instead of bolstering the faith of people in the judiciary, we are rather saying that the judiciary is corrupt. But if you ask for evidence, then we say it is perception. So the most important thing is that we must be bold. If we have physical evidence, we must use to substantiate. Otherwise, we shall be talking about perception, because any person who goes to court and loses, the person's position is that because he did not pay bribe, he or she has lost. But it is not the matter. The case is bad. So apart from training, we need to conscientize ourselves. Then the third antidote is that if a public officer corrupts himself, that person must be prosecuted. Thank you.